Hi, Darin Mangum again, the PPM attorney. I thought I would get on and do another couple series of videos that talk about, again, common things that come up in the connection with doing a private placement. One question I get is, what's the significance of filing Form D with the SEC, and what is that all about, and why? And if I don't file it, what's the big deal? Certainly, Form D is filing Form D, claiming exemption under Regulation D. It's not the only available exemption. There are obviously other either state or federal statutory exemptions that Congress has passed under the Securities Act that you could claim. But however, Form D is always the best choice because and in some cases, it's an essential choice, and I'll get into that in a minute. But like, for example, if you're filing under Regulation D, Rule 506C, you're basically doing a public solicitation of accredited investors under the new form, or the new Rule 506C that allows for general solicitation. There is no other exemption that is available, either federal or state, that allows you to do that without registration. And so if you fail to file Form D claiming that exemption, it could be just a death sentence for your offering, right? Not to say that, again, you couldn't file it late and claim it anyway, but certainly that's going to be a red flag. But certainly with respect, the best practices is to file Form D. Usually for clients, we file that after we've drafted the PPM, after we've done all the subscription documents and corporate work that's necessary to prepare the offering. We usually file Form D at the very end, right before you're ready to go to market. And so, but technically, you're not required to file Form D until 15 days after the sale of securities. But again, you don't want to wait to the last minute to do that. Form D, if you ever look it up, I mean, again, you can go to the SEC's website and look up any company under Regulation D or that has filed a Form D on the Edgar system and see what it contains, basic information about the offering, name of the principals, how much you're raising, what type of industry you're in, and things of that nature. So it's important that information is reflective of the information that is in your PPM. You don't want to have a disparity between what's set forth in the PPM and what is on your Form D filing. So certainly it is if the SEC ever looks at you or looks at your offering, that's one thing they're going to check right off the bat. Hey, have you filed Form D? And if not, why? And then of course they're going to ask for the PPM as well. So again, if you've conducted an offering and you haven't filed Form D, it's not the end of the world. You could still file Form D. And claim the exemption, and obviously the facts and circumstances will dictate whether you can satisfy the requirements of the exemption. However, it's just best to get it done right away, and that's something that we usually start the process in for clients right away. We get their Edgar filing codes and the SEC Form D filed in connection with the PPM, so that's all taken care of. So anyway, but that's a little thumbnail sketch on Form D. Anyway, happy to answer any questions you have about it. If you want to give me a call or shoot me a text or an email, happy to go over the particulars on that, and hope to see you and talk to you soon. Thank you for watching.